I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. In this video, we're continuing our series on the EB-5 Immigrant Investor Visa, also known as the Millionaire's Green Card. Specifically, we'll talk about whether loan proceeds can count as a cash investment for purposes of the EB-5 Green Card. Before we dive in, please take a moment to subscribe. We'll keep you updated on our firm's most current and trustworthy information about U.S. immigration, including options to visit, work, or live in the United States. One of the first things that comes to people's minds when you mention the EB-5 Green Card is money. That's because someone applying for an EB-5 Green Card must invest either $800,000 or $1,050,000 into a business. The amount depends on whether the business is located in a rural or a high unemployment area, also called a targeted employment area or a TEA. But either way, we're talking about a lot of money. So it's not surprising that people want to know what can count toward that investment amount. Fortunately, you don't need to have $800,000 sitting in your bank account to apply for an EB-5 visa. One option applicants have is to take out a loan and invest the proceeds from the loan into the EB-5 business as cash. This was the exact scenario that was at issue in a 2020 case called Zhang versus USCIS, which was before the U.S. Court of Appeals for the District of Columbia Circuit. We're going to take a few minutes to look at this case since it has some important lessons for anyone who wants to use loan proceeds toward an EB-5 investment. In Zhang, two EB-5 applicants whose applications were denied sued USCIS. Both applicants had invested into the EB-5 business funds that they borrowed from other businesses that they controlled. These other businesses had nothing to do with the EB-5 business. USCIS denied their EB-5 applications, saying that the loans were not a cash investment, but were instead indebtedness. This distinction between cash and indebtedness is important, especially in the context of an EB-5 application. So long as the cash was lawfully acquired, a cash investment automatically qualifies as capital under the EB-5 regulations. Capital is automatically counted toward the required investment amount. Indebtedness, on the other hand, can only qualify as capital and count toward the required investment amount if it is secured by the applicant's assets. Since the applicants in the Zhang case could not show that the loan was secured by their assets, USCIS refused to count the loan proceeds toward the investment amount, and they denied the applications. The court disagreed with USCIS and overturned the denial. The court held that loan proceeds that are invested into the EB-5 business are cash and are not indebtedness. As a result, loan proceeds should automatically count as capital toward the required investment amount, again, assuming that they're acquired lawfully. Let's take a closer look at why, since the court's analysis gives us better insight into how USCIS approaches these applications. Indebtedness, in the context of an EB-5 application, is when the applicant promises to give something to the EB-5 business. An example of this would be a promissory note, in which the applicant promises to pay the business some amount of money in the future. Now, it's important to note that on March 15th, 2022, a new law was passed, the EB-5 Reform and Integrity Act, which explicitly prohibited promissory notes or other debt arrangements between the EB-5 investor and the EB-5 business. However, for applications filed before March 15th, 2022, promissory notes were, at least based on the regulations, acceptable. Now, it makes sense that the government would require the applicant to secure a promissory note with his or her assets. Otherwise, the EB-5 business would have no recourse if the applicant were to default on the note, which would mean that the business would have no money to create jobs. And creating jobs is the fundamental purpose of the EB-5 program. In this sense, it's also understandable that the law does not allow EB-5 applicants to secure indebtedness with the assets of the EB-5 business itself. As with an unsecured debt, a debt to the EB-5 business that's secured by the business's assets could rob the EB-5 business of the benefit of the investment if it fails to materialize. So what about loan proceeds? Why aren't they indebtedness? Because when proceeds from a loan are invested into the EB-5 business, they're as good as cash. For example, if you're selling a car for $30,000 and someone comes to you with $30,000 in cash wanting to buy the car, you probably don't care whether they got the money by taking a loan out from the bank. As long as they can pay you for the car, it doesn't matter whether they got the money from a loan, a paycheck, or a gift from their wealthy uncle. It's no different for an EB-5 business. Once the proceeds from the loan are invested into the EB-5 business, the business has the cash to use as it wishes. This is not a debt to the business. It's cash. If you do plan to go down the route of using loan proceeds toward your EB-5 investment, remember to document. USCIS will still require a full accounting of exactly where the invested funds came from, even if they're proceeds from a loan. We hope this video about the use of loan proceeds in an EB-5 application was helpful for understanding how to qualify for an EB-5 visa, even if you don't have $1 million sitting in the bank. If it was, please click the like and subscribe buttons to stay updated on future videos about visa options and travel to the US. Thank you for watching.